dear students, as I told you in the previous lectures, we can say that we finished the first theory of criminal law theories, which is the theory of the crime. So we knew what the crime is, what are the main pillars of the crime or the main elements of the crime, the actus reus and the mens rea. We discussed different matters regarding the material element, like the attempt and the other topics. Inshallah, now we will move to the second theory in the field of criminal law, which is the theory of penalty. So this is the course syllabus, and these are the topics that I'm going to cover during this semester. So the course mentioned here, entitled Penal Law Part 2, will include the following topics. First of all, we're going to define what is the criminal penalty, what are the types of the criminal penalties. I mean the categories of the criminal penalties, whether they are precautionary arrangements or even punishments. لأنه الجزاء له نوعين، في العقوبة اللي هي البانشمنت، في تدبير الاحتراز اللي احنا بنسميه precautionary arrangements أو بنسميه precautions. So we are going to shed a light on the difference between the punishment and the precautionary arrangements. We will mention the characteristics of the punishment, what are the features of the punishment, and the general features also of the precautionary arrangements, because knowing the characteristics or the general features of both will help you knowing the difference between both the punishment and the precautionary arrangements. And the first difference can be discovered from the definition, as I will show you after minutes. So number 4 here, the precautionary arrangements and the Palestinian legislation. What is the position of the precautionary arrangements in the Palestinian legislation or the Palestinian penal codes? What I mean here is how the legislature uh, dealt with the precautionary arrangements in the Palestinian system, the types of the punishments، أنواع العقوبات بشكل عام. ولاحظ أنا هنا بديت أتكلم عن ال punishments ك one of the categories of the criminal penalty. Punishments according to the criminality degree، أنواع العقوبات بحسب درجة الجسامة اللي هم ال felonies, misdemeanors and contravention. We're going to know in details what do they mean. Punishments according to their duration, like lifelong imprisonment or imprisonment for life, or even a sentence for a specific number of years in jail. So we are going to differentiate between these punishments according to their duration, punishments according to their to the right which is affected by the punishment, whether this punishment is against the body of the person or the accused, or even it is against his money, like fines. So the punishments also according to their fellowship and independency, whether it is original punishment, subsidiary punishment, complementary punishment. So we are going to shed the light on these different categories of the punishments according to their independency and fellowship. Then we're going to assess and to illustrate in details the first punishment, which is the capital punishment or the death penalty. We will know the assessment of such punishment in the legal system, whether in Palestine or outside Palestine, and the guarantees to apply such penalty. Then we will move to the punishments against the liberty, their types, the execution of such punishments, and the duration of these punishments, pecuniary punishments, their value and the estimation of such pecuniary rights اللي احنا بنقصد فيها العقوبات المالية يعني، أهمها الغرامة والconfiscation. The number 13 here, the discretion of the judge in determining the punishment, the limitations imposed on the judge, and the guarantees which guarantee that this judge will not abuse the discretion which is granted to him by the law. معناتها انه في هذا الموضوع تحديدا، يعني لما بتكلم عن سلطة تقديرية للقاضي، أنا بحكي عن مسألة إمكانية تطبيق ولا مانع من موانع العقوبة dismissal of punishment or the reasons of mitigation and aggravation، أسباب تجديد العقوبة أو تخفيف العقوبة. فعشان هيك حتكلم أول شيء عن dismissal of punishment، إحنا بنسميها ال punishment impediments، موانع العقاب. بعدين حنتكلم عن ال mitigating excuses and circumstances، الظروف المخففة والأعذار المخففة، لأنه there is difference between العذر المخفف اللي احنا بنسميه mitigating excuse because it's mentioned explicitly in the legislation, and the mitigating circumstances which it's not mentioned in the legislation. However, the judge can activate it himself through the discretion which is granted to him by virtue of the law. The aggravating factors will be discussed later. So what do we mean by the aggravating factors؟ اللي هي العوامل التجديد، سواء كانت عوامل تجديد إجبارية بالنسبة للقاضي إذا شافها يجدد، أو اختيارية، يعني ممكن القاضي يكون له discretion regarding them whether to aggravate the penalty or not. So this will be discussed also. And I think that these matters are of very important nature, and they are the most amusing and knowledgeable ones. Okay, so you will feel that you have new knowledge in the field of criminal law when you take these topics, because they are really important. They are activated in the practical field. If you visit any court, you will find the judge applying them from time to time. So this is why I told you that they are very important. We will discuss the recidivism، اللي هي حاجة بنسميها العودة إلى الجريمة وتكرار الجريمة، متى يكون الشخص عائد ومتى ممكن أعتبرها multiple crime، جريمة متعددة، أو تعدد مادي للجرائم، إحنا بنسميه material multiple crimes. So there is difference between the recidivism، العودة إلى الجريمة من الشخص اللي ارتكب الجريمة مثلا، أو إنه نقول إنه هذا الشخص ارتكب تعدد في الجرائم. تعدد الجرائم المادي اللي بيرتكب الشخص أكثر من جريمة أكثر من مرة بيختلف عن العودة إلى الجريمة. يعني واحد ممكن نقول for example أحمد مسعود committed the crime of theft 3 times a week or 3 times in 1 week. Okay, this is multiple crime, material multiple crime، هذا تعدد مادي للجرائم. متى ممكن أقول عنه recidivism؟ كنقطة أولية نبدأ فيها هيك، إذا كان أحمد مسعود committed the crime of theft, then he was prosecuted and he was condemned by the court by a final judgment, and he was exposed to the judgment or the sentence, and he was put in the jail for 2 years, for example. Then he was released after that. After his release, he committed another crime, whether it is a crime of theft or any other crime. This is the recidivism. هذا بنسميه العود. So the difference between the multiple crime and the recidivism is that in recidivism, the person commits or returns to the field of the crime after he was released, after he was condemned, and there was a judgment which isolates between the two crimes, the new one and the old one. There is a verdict, there is a ruling or a judgment or a sentence. However, in the multiple crime, the person commits more than one crime. However, there is no sentence between them. The person was captured after he committed 3 crimes. This is multiple crime. This is material multiple crimes. Okay. Then we will move to the suspension of punishments. هنحكي عن نظام وقف العقوبة. تسمع مرات بقول حكمت المحكمة عليه بسنة مع وقف التنفيذ، يعني الشخص بيطلع سنة مع وقف التنفيذ. So the suspension of the punishment هو وقف التنفيذ. We will know what are the conditions of such system or discipline. Then the discretion and impacts of the suspension of crime. We will move then to the parole system. نظام الإفراج اللي هو احنا بنسميه conditional release، الإفراج الشرطي عن الشخص. واحد قضى ثلثين المحكومية، سلوكه يدعو إلى القول بأنه هذا الشخص مش حيرتكب أي جرائم فيما بعد. سلوكه قويم داخل السجن، بتروح الإدارة تبعت السجن تعطيه conditional release، إفراج شرطي عن الثلث المتبقي من المدة. إذا يعني هو تعديل في العقوبة، إنه بيقضي العقوبة خارج السجن بدل من إنه يقضيها في السجن. هو مش تعديل في العقوبة، عفوا هو تعديل في نظام تطبيق العقوبة، وحنناقش موضوع البارول بالتفصيل فيما بعد. ضروري نعرف يا أخوان إنه these topics will not be addressed يعني gradually. I will select them according to their importance. So you will find me sometimes taking a topic number 1, then moving to the topic number 7, then topic number 16, or even number 21. So all you have to know or to do is to follow my lectures and to know where did I stop, to know what are the topics that are included in the final exam. Okay. في عندي كمان موضوع هنا numericity and its impacts on the punishment، التعدد وأثره في العقوبة، تعدد الجرائم وأثره على العقوبة، هل بتشدد ولا بتشددش العقوبة. the termination of the penalty، أخيرا انقضاء العقوبة. هنتكلم كيف تنقضي العقوبة، هل تنقضي بالتنفيذ الفعلي للشخص لعقوبته داخل السجن اللي احنا بنسميه التنفيذ الحقيقي، ممكن تنقضي بطرق أخرى، ممكن الشخص يهرب فتنقضي بالتقادم اللي احنا بنسميه prescription. ممكن نتكلم عن موضوع الامنستي، العفو، أو احنا بنسميه pardon. يعني amnesty or pardon it is the same. However, amnesty is used in the international courts. Pardon, I think it is used within national documents. Termination of criminal record، ونتكلم عن كيف السجل الإجرامي السوابق. مش بنقول أحيانا الشخص من أصحاب السوابق. إيش يعني أصحاب السوابق؟ يعني لو بده يطلع شهادة حسن سير وسلوك مش حيقدر. ليه؟ لأنه وزارة الداخلية عندها سجل سابقة إجرامية بالنسبة للشخص، ولو راح على وزارة العدل لن يخرج شهادة عدم محكومية لأنه عمليا في حكم سابق. فكيف بدك تطلع له شهادة عدم محكومية والشخص هذا لم يسبق وأن حكم، هو عنده حكم سبق وأن حكم يعني أو سبق وأن نفذه. فالشخص هذا وقت بيضل طول حياته يعني سجله الإجرامي موجود لدى هذه الجهات وما يقدرش يطلع شهادة إنه نظيف وما عندوش سوابق. فوقتش بينتهي؟ When does this criminal record terminate؟ متى ينتهي ويسقط السجل الإجرامي هذا اللي احنا بنسميه محو آثار الجريمة. So we will discuss the types of this termination of the criminal record and the impacts of this termination. Okay. The evaluation methods mentioned here, they do not apply to you because they apply to the face-to-face learning. However, you know what are the way that I assess you during this semester, as you have 3 assignments for 30 marks. One midterm exam is for 20 marks, so this is the first 50 marks, and the final exam is 50 marks only. So this is all I wanted to illustrate before getting to the first topic of the theory of penalty. So let's move now to the first topic here. طبعا يا إخوان للأمانة العلمية this material is not made by me or it's not prepared by Maher Masoud. It's made by Mr. Muhammad Abu Hashim. I found it really suitable. That's why I depended on it. in illustrating some points. Not all the matters, however, some matters. So the definition of the criminal penalty. What is the criminal penalty? The criminal penalty can be defined as the reaction of the society against the criminal. أبسط تعريف للعقاب أو عفوا الجزاء الجنائي، لأنه ما بقدرش أقول عقاب لأنه العقاب جزء من الجزاء إلى جانب التدبير الاحترازي. That's why I read it as criminal penalty, not criminal punishment or even precautions. So the criminal penalty is defined as a reaction، هو عبارة عن ردة فعل اللي بيحملها مين؟ The reaction of the society against the criminal، هو ردة فعل المجتمع تجاه المجرم على فعلته الإجرامية. لأنه when the criminal commits the crime he breaches not only the private interest of the victims but also he violates the public order وبنتك النظام العام، the public safety of the society، النظام العام للمجتمع. So in the crime of murder the person he kills his victim but at the same time he threatened the society, the national society, the safety of the society. That's why we say that the penalty is the action or the reaction of the society against the criminal person, which is enacted by the legislative authority. واللي طبعا ردة الفعل هذه اللي بيعبر عنها المجتمع لا توقع مباشرة من المجتمع، يعني مش الناس اللي حتروح تعاقب الشخص، هي ردة فعل المجتمع تلمسها المشرع وقال إنه المجتمع في جرائم القتل حتكون ردة فعله عنيفة جدا، لذلك يجب أن أضع نص عقابي يشفي صدور الناس الموجودين في المجتمع، فحط عقوبة مغلظة. وكذا الأمر بالنسبة للجرائم الأخرى، يعني السرقة قال لك هذه بتهددش أمن المجتمع بنفس الدرجة اللي بتهددها جريمة القتل، لذلك the penalty will be something else. It may be 1 year to 3 years max. That's why the penalty in the crime of theft is different from the penalty in the crime of murder because of the effect of this crime on the national society and the public order. Since the magnitude of the effect is different from one crime to another crime, this will be reflected in the criminal penalty which is enacted by the legislative authority. So it is a reaction, it is practiced by the society against the criminal through a legal text made by the legislative authority، ولهذا تعبير عن قاعدة no crimes and no penalties without a legal text, and it is applied by the judicial authority، طبعا اللي بتطبق بواسطة السلطة القضائية. هو اللي بقصده هنا بموضوع it is applied يعني the judge is the one who decides what is the sentence that must be given to the criminal. However, the real application means putting this person or making this person undergo the the sentence in real which is the function of the executive authority. طبعا السلطة التنفيذية هي اللي بتنفذ العقوبة عليه، لكن تطبيق العقوبة بالمعنى اللي قصده هنا applied by the judicial authority معناته to decide what is the appropriate or even the suitable judgment which fits with the criminal act committed by the criminal. So this is the best definition from my point of view of the criminal penalty. So it is a reaction, it is practiced by the society against a criminal through an enacted legal text, might be by the legislative authority, applied and verified by the judicial and executive authorities. Okay, penal codes applied in Palestine generally. We have three penal codes. The first one is the Penal Code 74 of 1936, and it was made during the British Mandate era, not yet. So it is enforced in the Gaza Strip only. Okay, and this is not new information for you. Second one is the Penal Code 16 of 1960. It's a Jordanian law. It was made by Jordanian Legislative Authority. However, it's enforced only in the West Bank. The final one, it is applied in both Gaza Strip and the West Bank, is the Revolutionary Code of the Palestinian Liberation Organization, قانون العقوبات الثوري تابع لمنظمة التحرير 1979. It's enforced in both regions for crimes that are committed by military persons with regard to their works. طبعا or by virtue of their works. هذا قانون العقوبات الثوري بينطبق فقط على العساكر واللي بيرتكبوا الجرائم طبعا بحكم وظيفتهم، بحكم عملهم يعني. اليوم المعيار في محاكمة الأشخاص قدام القضاء العسكري معيار شخصي وأحيانا موضوعي. يعني إذا كانت الجريمة مرتكبة بواسطة مدني بس بتمس بالأمن العام وبسلامة الوطن زي جرائم الخيانة والتجسس وغيره بحولوهم على القضاء الشرعي. وإذا كانت الجريمة متعلق على القضاء عفوا العسكري، وإذا كانت الجريمة من شخص عسكري بحولوه على القضاء العسكري. وإن كان في توجه اليوم إنه بعرفش إذا نطبق حتى الآن أو لا، إنه الشخص العسكري لو كان جريمته مدنية بحتة ملهاش علاقة بحكم وظيفته أو بالأعمال العسكرية، فالمفترض إنه this person must be prosecuted and litigated before the civil courts. يعني the normal courts like the court of conciliation or court of first instance where the normal people are litigating or making their pleading in the normal course of circumstances. Okay, so I mentioned them because we're going to study the some kinds of penalties according to these laws. For example, when I discuss the death penalty, for example, I will address the topic of the capital punishment or the death penalty in both laws, the law applied in Gaza and the law applied in the West Bank. The parole system will be discussed according to both laws. Okay, so that's why he mentioned them in this way. Classification of penalties, inshallah. In the coming lecture, I'm going to classify the penalties, mean the precautions versus the punishments as kind of the penalties. That's why I told you here criminal penalty, not criminal punishment, because the punishment and precautions are both penalties. Okay, so to make the the definition a comprehensive one, we have to use the word criminal penalty instead of both words. Thank you very much. See you inshallah in the coming lectures. Goodbye.